What is the arraignment process? Well, the arraignment process is when a person who's been accused of a crime and taken into custody sometimes, or has already been released from custody, is taken before a judge who arraigns the person. That is, the judge tells the person what they're charged with, what the possible punishment could be, and then may or may not ask the person to enter a plea. That usually does not happen at a first arraignment and should not happen without the person having counsel available with them. So arraignments where the person does not have counsel usually just involve the person being told what they're charged with, and then also generally having bail determined. If the person is represented by counsel, then the arraignment may involve being told what they're charged with and asking the person to enter a plea. So generally a person who's represented by counsel at arraignment will enter a plea of not guilty so that the case can then proceed further and the attorney can then start defending by investigating the case and doing everything they can to properly represent the person to get the best possible result. There are many different types of pretrial hearings. Sometimes those pretrial hearings just involve appearance before the court, where the court inquires if the two sides have come to an agreement or if they need to set the case for a jury trial. Sometimes pretrial hearings may involve hearing specific issues. There could be a hearing on a motion to suppress where the defense is alleging that the government or the police did something illegal and that any evidence that they obtained from that should not be admitted into evidence. It's the fruit of the poisonous tree. It's something that was obtained illegally, and they're asking the judge to rule that that evidence be suppressed. Sometimes the hearings might be hearings regarding reasonableness of bail or hearings regarding a claim of excessive bail. Sometimes the hearings might involve determining discovery issues, requesting specific evidence in a case. Sometimes the hearings might involve having the judge order the government to disclose certain things, like any benefits conferred on any witnesses. So there's many different things that can be heard or decided on pretrial hearings. But then basically anything regarding the decision of guilt or innocence will be heard at trial, either before a jury or before the judge if both sides waive a jury. Who's responsible for gathering the evidence in a case? Well, this is kind of a complicated answer because, first off, the government is responsible for gathering the evidence to decide whether a person should be accused of a crime or be tried for a crime. But once the person is has been accused of the crime, indicted, or charged by information or complaint in a misdemeanor and appearing in court, then it's going to be incumbent on the defense attorney to make sure the government complies with their responsibilities. The government is responsible for disclosing the evidence in the case to the defense, but you must have expert representation to make sure that the government stands by their responsibility to disclose the evidence in the case. So the government is responsible for disclosing all the evidence that they have in the case and disclosing any favorable evidence that they have as well. To make sure that this happens favorably and effectively, you need expert representation that makes sure that the government has, first off, that they have demanded that the government disclose all the evidence that they have in the case, then make sure that the government complies with that demand, then determines whether or not it looks like there's other evidence that should be disclosed or other evidence that's not being disclosed. So it's incumbent on the defense attorney to make sure that the government complies with their obligations to disclose the evidence in the case. What to expect at trial? Well, the trial can last anywhere from a day to weeks or more, depending on the case and the complexity and the amount of evidence. But many misdemeanors, even DWIs, will usually be resolved in 1 to 2 or 3 days. So you might spend a half a day picking the jury, and then it might just take half a day to hear all the evidence and have the jury decide the case. Or it might take several days to hear all the evidence in the case, and then another day for the jury to decide the case. Jury deliberations can sometimes, in complicated cases, take several days, but quite often they don't take more than an hour. So a trial can last from a day to even several weeks, depending on the complexity of the case. Know what to expect in your case, from arraignment to pretrial hearings to actual trial. Be sure to hire expert representation so you can know exactly what to expect in your case from attorneys who actually have experience in going to trial and winning trials. Hire the Medlin Law Firm.